If a person lands on top of another party's car during a car accident, can the person be considered an occupant of the other party's car? We'll get the answer to this question and see how the Alaska Supreme Court interpreted terms in an insurance policy in Hahn versus GEICO Choice Insurance Company. Chad Hahn was sitting on his motorcycle at a stoplight. Franklin Townsend was driving a vehicle and struck Hahn from behind at the stoplight. As a result of the impact, Hahn was thrown onto the hood, windshield, and roof of Townsend's car before Hahn eventually landed on the road. Townsend was insured by GEICO, and his policy provided up to $50,000 each of bodily injury liability and property damage liability per person. However, Hahn's hospital bills totaled around $160,000. Hahn sued Townsend for negligence and intentional torts. GEICO offered to pay the bodily injury coverage and property damage liability coverage from Townsend's policy. Hahn's attorney also requested that GEICO pay $50,000 of underinsured motorist, or UIM, benefits from Townsend's policy, which covers any person occupying the insured vehicle. Hahn argued that when he landed upon Townsend's car, Hahn occupied Townsend's car under the policy's definition of occupying. Townsend's policy defined the term occupying as, quote, in, upon, getting into, or getting out of, unquote, the vehicle. GEICO sought a declaratory judgment that Hahn wasn't eligible for the UIM coverage from Townsend's policy. The Alaska Superior Court looked at previous case law and the context of the word upon under the doctrine of nascitur aesacis, which holds that the meaning of a word can be gleaned from surrounding words. The court granted summary judgment in favor of GEICO. The court found that, based on the context of the word occupying, Hahn didn't occupy Townsend's vehicle when Hahn landed upon the car during the accident. Hahn appealed to the Alaska Supreme Court.